In a stunning move, the Supreme Court has abolished all firearm permit systems nationwide. State and local requirements for handgun licenses, concealed or open, are now void. This is the most sweeping change to Second Amendment law in modern history, creating a new, uncertain landscape for gun ownership. The court's order, brief and unsigned, has left millions scrambling to understand what comes next. Permitless carry is now the national standard, replacing a patchwork of state laws. The majority argued that requiring government permission to exercise a constitutional right is unconstitutional. Supporters hail this as a restoration of rights. Critics warn it endangers public safety. The Department of Justice in several states have backed the ruling, citing the confusion and inequality of the old system. State agencies that once processed permits are shuttered, and decades of gun control laws have vanished overnight. The nation now faces a reckoning. Is the right to bear arms absolute, or can it be limited for public order? This ruling is the result of a legal journey that began with the 2022 Bruen decision. Bruen required gun laws to align with historical tradition, invalidating restrictive permit systems and sparking nationwide legal challenges. Lower courts struggled, leading to a fractured legal landscape and mounting confusion. The Supreme Court intervened, consolidating cases that argued even shall-issue permits were unconstitutional burdens. Plaintiffs claimed that fees, training, and waiting periods infringed on fundamental rights, and that history showed no tradition of licensing self-defense. The court agreed, declaring government-issued permits inconsistent with the Second Amendment's text and history. Rather than referee endless disputes, the court opted for a clean slate. The right to carry is now the default. No permit system is constitutional, ending the debate over their form. This legal reset redefines the relationship between citizens and the state on firearms. The DOJ and a coalition of states support the Supreme Court's decision for reasons of efficiency and clarity. Navigating a maze of permit laws, complicated enforcement, and interstate investigations, a single national standard lets law enforcement focus on violent criminals, not permit compliance. States with strict gun laws joined in, citing the legal costs and futility of defending permit systems after Bruen. Supporters argue permits didn't prevent crime. Most gun violence is committed by those already barred from owning guns. Removing permits, they say, empowers law-abiding citizens and deters crime. The ruling ends legal chaos, providing a clear rule for gun owners and police. The DOJ and states now aim to build a new public safety framework within these boundaries. The Supreme Court's decision sent shockwaves through every corner of America. In Texas, Sergeant Miller told his officers, "Permits are gone, focus on behavior, not paperwork." In Oregon, gun owner Sarah surrendered her now worthless license, feeling both liberated and uneasy. The deputy nodded. End of an era. In Chicago, community activist Maria mourned. "What about our right to live? This isn't freedom, it's a nightmare for us." State officials in California scrambled to respond, shifting focus to expanding sensitive places and reinforcing red flag laws. The Attorney General declared, "We lost one pillar of safety, we must fortify the rest." Across the country, reactions ranged from relief to fear. Police departments rewrote protocols overnight. Gun owners celebrated newfound freedom, while others worried about public safety. The nation was united only in uncertainty. The debate over rights and safety had never felt more personal. America was changed instantly and irrevocably. For police, the end of permits means a new era of uncertainty. Officers can no longer ask for a carry permit during stops. They must focus on behavior and criminal records. This shift demands more training and judgment, as the absence of a permit is no longer grounds for suspicion. Verifying if someone is a prohibited possessor now requires time-consuming background checks. Police unions worry this could make officers more hesitant to engage, potentially letting illegal carriers slip by. The change also risks new tensions. Asking about a gun could be seen as overreach. Departments are rushing to update training and guidelines to balance safety with rights. Whether this shift improves or endangers public safety remains to be seen. With permits gone, the fight shifts to sensitive places, where guns can still be banned. Historically, these included courthouses and schools, but states now seek to expand the list to parks, transit, and more. The Supreme Court's order didn't resolve this, setting up a new wave of legal battles. States argue broad bans are essential for safety. Gun rights advocates call them unconstitutional. Courts must now decide if history supports bans in places like hospitals or stadiums. Conflicting rulings are expected, and the Supreme Court may have to step in again. The outcome will define where Americans can carry for years to come. The debate over safety versus rights is far from over. America now faces a period of rapid legal and social change. States will rush to expand sensitive places, triggering lawsuits and more court battles. Experts are divided. Some predict more violence, others see little change. Gun owners must stay alert to shifting laws. Businesses must decide their own policies. The ruling forces a national conversation about responsibility, safety, and freedom. The Supreme Court has answered the permit question, but left many others open. The future of gun laws will be shaped by courts and legislatures, not licensing offices. One thing is certain: the Second Amendment debate is far from settled.